Good morning, everybody. Welcome to the second lecture in commercial law. Today's topic and next week's topic is focused on agency. Agency is another basic concept in commercial law, just as property rights and bailment, possession are, that we looked at in the last lecture. But unlike the other subjects, other concepts, you might not have come across agency before. And yet, agency is at the heart of commercial law relations and transactions. It underlies a vast range of transactions. In practice, it's absolutely crucial and also quite complex. So we need 2 lectures to look at some of the aspects of agency. This lecture will involve a little bit more of me talking than last lecture, but I still would like to give you an opportunity to ask questions if you have any questions. But perhaps rather than ask questions throughout, I'll set aside some time during the lecture for questions then, and I promise there will be some time, okay? Just to manage the content, because there's a lot more this lecture than there was last lecture. Is that okay with everybody? If you have a question that you want answered, try this in this lecture. If not, feel free to email me. I really welcome questions by email too. But we need to make sure we cover the area as well. So, agency is notoriously difficult to define because I suppose it appears in a various range of forms and in various contexts. And because the term is also frequently used in practice incorrectly to mean transactions which do not involve agency as we know it in commercial law, in law in general. So first, let's start. Yes.
Is it possible to use a microphone? It's a little bit
Right. Good question. Now let's see whether any of those. Okay, this is flashing as red. Does any of this help? No. So both of those right. I cannot see an obvious microphone here, so I'll try to speak up as much as possible. Okay, I'll do the classical. There are some spaces at the front. If anybody would like to move, feel free. I will try to look into the microphone availability in the break, but I'd like to just move on. Is that okay for a moment? I'm sorry. Can you hear me though at the back, or not at all? So I'll try to. Right. So let's start with a very basic example, just to get us thinking about the right concepts. Obvious question, have you bought anything from a shop? Yeah, supermarket, for example. So when you go in, you ask for, say, a chocolate bar, and the shop assistant sells you a chocolate bar. Now you buy the chocolate bar, you render the amount of money that's required for it, and the person gives you the chocolate bar. Or you do it automatically through the till. Now you interact with a shop assistant, right? With a person of the shop assistant, leaving aside the automated tills. Shop assistant. Now, who is your contract with? You have concluded, you made your offer to buy the chocolate bar to the shop assistant. The shop assistant took your money, gave you the chocolate bar, and you walk away. Who is your contract of sale with?
Store owner?
Why?
Because they're the persons who set out to benefit from the transaction, set up the circumstances of the transaction and then benefit from the transaction, and the shop assistant is a facilitative intermediary.
Right, so your contract is with the shop owner. The shop, if the shop is a company, a corporate entity, it will be the party to the contract. The shop assistant acts on behalf of the shop, or the shop owner, if that's a person. And that's because there has been a prior arrangement between the shop assistant and the shop owner, the shop, if it's a big supermarket, say Tesco's, or there is a contract of employment or some other form of contract, as part of which the shop assistant is granted authority to sell goods on behalf of the shop. So if your chocolate bar, despite being still within the best before date, is inedible, it's gone bad for some reason, and you want to seek recourse, you will go to the shop, you will try to resolve the matter with them, not the specific person that sold you the chocolate bar. In fact, that person may no longer work there. They act as a facilitator. And why do we employ such facilitators? For practical reasons. A shop owner might not be able, if they're an individual, to serve a number of customers, to conclude the number of contracts that they need to conclude to make their business flourish. But many businesses operate as companies, as corporate entities. Such entities do not exist physically. Agreed? So they must have agents, individuals, that will act for them. Directors, for example. So basic agency involves the principal, in my example, the shop, it might be the trading company, for whom another person will act. There will usually be a prior relationship between the principal and the agent. There is also the person of the agent, and I just had a diagram to show you, but not to worry. Agent, third party, and principal. And the third party with whom the agent will have some sort of interaction. So the interaction that the agent enters into with the third party, you the customer, in my example, was a contract. Contract for sale of a chocolate bar. But it does not have to be entering into contract on behalf of the principal that the agent is embarking upon. It could be that the agent has been asked by the principal to give notice, to make a communication on behalf of the principal. And it's important to realise that although the majority of the cases in practice and those that we look at will involve a contract being concluded for principal, it does not have to be a contract that is entered into between the third party and the agent. So it's, for example, a contract. Now, what happens when the agent enters into this interaction, for example, a contract with a third party? The magic of agency takes place, and this contract is concluded, in fact, not between the facilitator and the third party, but the principal. In my example of buying a chocolate bar, the contract is not between the shop assistant and you buying the chocolate bar. It is between the shop who asks the principal, the agent, to act on their behalf to sell the chocolate bar, and by virtue of entering into a contract, automatically, so to speak, the legal relationship, the same legal relationship arises between the person on whose behalf the agent acted and the third party. So there is a distinctive character that the agency has. There is a prior arrangement, consensual arrangement between the agent and the principal, by virtue of which the principal consents to agent acting on their behalf, and the agent assents to acting on principal's behalf. So the relationship between principal and agent is another relationship which is pre-existing in the classical form of agency, in a basic form of agency, to the later act that the agent undertakes on behalf of the principal. And this relationship between the agent and the principal is frequently in the form of a contract. The principal makes an offer to the agent: will you act on my behalf? It could be part of contract of employment, but doesn't have to be. And the agent says yes, accepting the offer. There may be a commission, or there could be, more frequently, some form of salary. But again, there is no, this is only an example by which the principal and the agent can interact with one another. Now, what I wanted to show you is, all right, this looks promising. Okay. So I said that, do you see a sponge or something? Let's wipe that out. So throughout the lecture, we'll use abbreviations: P for principal, A for agent, X for third party. Now, there are a number of definitions of agency, and there are a number of them because it is a complex area, and it's useful to look at a few because they will highlight different aspects of agency. So there is first the agency definition from the Restatement of Law by the American Law Institute, and it highlights the same aspects we've just talked about, that agency is a consensual relationship between the principal and the agent. It's usually, almost always, a fiduciary relationship, so there are aspects of loyalty. And the agent's job, their role, is to conclude a legal act, for example, a contract, on behalf of the principal. For example, to enter into a contract, to make an offer, or to communicate acceptance on behalf of the principal. It could also be a discharge of contract. It could be to make a payment on behalf of the principal, and making of the payment on behalf of the principal will discharge the principal's obligation to pay that is owed to the third party. When the agent enters into a contract with the third party, the agent does not become bound to the contract with a third party. It is the principal, at least in the classical form of agency. And Sir John Donaldson in Culture and Customs highlights the wide variety of agency relationships that are out there. But he also says that from the perspective of the third party interacting with the person of the agent, they might not necessarily know whether they're interacting with someone acting independently on their own behalf or on behalf of someone else. So it could be that they're acting independently, and in that case, if they are acting independently, the next question is, are they truly acting on their own behalf as the principal, or are they appearing to act independently on their own behalf, but really have a pre-existing relationship to enter into a contract on behalf of the principal? We appear to have some technical issues with this image today. It's back. If the agent appears to the third party to appear in their own capacity as the principal, but really is acting on behalf of somebody else, that is also a form of agency, which we'll look at in detail in the next lecture, and that form of agency is called undisclosed agency. But for now, in this lecture, we shall focus on the disclosed form of agency, when the third party is aware that the person with whom they're interacting is acting on behalf of someone else. They might not know exactly who, but they know that they're not acting for themselves. Now, you might be querying why we are starting with the definition from Restatement by American Law Institute. The restatements in the US in particular are very common, and they are statements, authoritative statements, of common law principles, principles that developed in case law, and they, as far as agency at least is concerned, they still carry, they're still important, at least as persuasive authority goes, in English law. So you will frequently come across in agency, more so than in other areas, that we are referring to the law that exists also in the US or Canada or New Zealand. That's not unusual, there's just more of it here than elsewhere. Now, there's Lord Denning in Phonogram highlights another aspect of agency. So when we are looking at agency, we said that there are different forms. The agent could be acting on behalf of themselves or someone else. And if they are acting really for someone else but not disclosing, that would be an undisclosed agency. But it's also possible that the agent is acting, appears to be acting on behalf of a principal to the third party, but really is not authorized, it's not, has not got the pre-existing relationship with the principal. So Lord Denning says that in Phonogram, in this definition that he offered, that the general principle is, of course, that a person who makes a contract ostensibly is an agent, cannot afterwards sue or be sued upon it. So that's the basic statement. But we have to contrast this with the other forms of situations where the agent could be either undisclosed or they could be only appearing ostensibly to be acting on behalf of the principal, but really not be acting at all. Now, more conceptually, what is agency? What does it mean that an agent is concluding a contract on behalf of someone else? Yes?
They're entrusted with a task, and they act in the interests of the principal. Could bailment be sort of a good example of different types of agency, insofar as one can consciously make someone else a bailee, but then again, you might pick up a piece of property and become a bailee by virtue of the circumstances?
Well, bailment is not, I don't think we could call bailment a form of agency, and we'll talk about the differences between agency and bailment in a moment. And perhaps it's very useful to go first with a more conceptual backbone of agency before we go to those distinctions between agency and bailment. So when we talk about what agent does when they enter into a contract on behalf of someone else, we need to think about the concept of power. Power. And you might have come across the idea of power before in your studies, but you might not have thought about it very much. So power, just as much as the concept of right, has been developed to a significant extent conceptually by Hochfeld, whom you no doubt studied or came across before. And you are probably quite familiar with Hochfeldian distinction between rights and, on the other hand, the correlative to rights. If I have a right to do something, what does the person against whom you have the right, what do they have? Someone at the end? Yep. Duty, of course, duty. So there is a correlation between right and duty. Hochfeld also came up with other forms of entitlement, which capture other aspects of legal entitlement in law. So, other than the right, a person might have a power to do something. So if you have a power to do something, what does the person against whom you are asserting the power have? Yep.
Liability.
Liability. What does it mean that the person against whom you are asserting the power have liability? What does it mean?
Will they be subjected to the power that the person A has against them?
And what does it mean that the person against whom the power is asserted is subject to that power? What does it mean? Do they have to do anything? If you have a duty, you might have to do an act to fulfill that duty. For example, if someone is asking you to pay, you're under obligation to pay. They have a right that you pay. So in order to discharge your duty, you have to undertake the act. With liability, there is not necessarily the obligation to act, but you are liable to tolerate the legal consequences of the exercise of the power by the person who has the power. Okay? Simple example. Every one of us has a range of powers, legal powers that we all carry. As individuals that exist in the law of society, and we're bound by law, but we also have certain rights and powers. I have a power to enter into a contract that is exercisable against everybody else. That means that everybody else is liable to tolerate, put up with the fact that I have entered into a contract. It might not necessarily affect their legal position, but in some circumstances it might. So, for example, if I have a power to pay a debt that someone asks me to pay, for example, a debt that my friend owes, and I have a power to discharge that debt, and my friend says, no, I don't want to pay this debt, I don't want to pay this parking fine, for example. I don't want to pay this parking fine. It might be their choice, but I might have a power as their agent to discharge the debt on their behalf. If I pay, discharge my power, my friend, who had the liability to pay will have the liability discharged automatically in law. That's the exercise of power on behalf of the principal, and the principal is subject to the exercise of that power. They're liable to tolerate the legal consequences of the exercise of that power. That means that an agent has the ability to change the legal relationships that the principal enters into. And this is really Dowrick's point. Dowrick was a scholar who wrote earlier in the 20th century, in the mid-20th century, about the concept of power. And his idea about agency was that agency is about the exercise of legal power, making principle liable to the exercise of that power, to the consequences that follow when the power is exercised. And he drew on Hochfeld, of course. He was inspired by Hochfeld. Now, the agent is usually also a person. There will be either an individual, there could be also a company, a corporate entity. So they will have power to enter into their own legal relationships. But that power to enter into their own legal relationships is replicated in agency. If they undertake to act as an agent, their power to conclude legal relationships is reproduced, duplicated, which is why Pollock talks about agency as the personality of the agent being multiplied in space. Because the agent is able to act not only, the person of the agent is able to act not only for themselves, not as agent, as in their own capacity, as an individual or as a company, but also if they are an agent, they can conclude acts and bind another person. So the agent has a power to alter the legal status, the status of legal relationships, not only of their own, but also of another person. Do you have any questions at this point?
Yes, who is exposed to liability and how much? So in the shop assistant example, so say the person buys a chocolate bar from the shop assistant, and then it turns out that the shop assistant has held the chocolate bar in circumstances such that it is gone, it's melted and it's not edible, then who, this is obviously a very basic example, but classically speaking, who's going to absorb the liability for that? And is it evocative of the independent contractor versus agent distinction made in tort?
I don't think so. The shop would be liable in that case. Even so, if the employer permits the employee to act, to perform certain acts in the course of employment, and storing chocolate bars, selling them in a particular way will be part of that, then the shop, the employer, the principal assumes the liability for any acts that the employee might do. And I would argue also in the case of independent contractors, there will be tortious liability owed to third parties if there is a problem with the chocolate bar because of the act of the employee or the contractor. This liability in tort law is referred to as vicarious liability. So have you come across vicarious liability before? Good. So it's part of that concept.
I'm a bit confused by what you said about the tort bit, but putting that to one side since we're not in a tort class, just to make sure I'm understanding what you're saying. The principal is going to absorb the liability normally, and therefore must be careful who they choose to be the agent, unless there's been some sort of contractual assumption of exposure to liability by the agent.
Right, of course, there will be the terms of liability. So there are two things there. So one is the relationship between the principal and the third party, the liability to the third party, and the question who is to be liable for example, damages to the third party. The answer in vicarious liability, the point of vicarious liability, is that it is the principal, not the actor, not the person who acted. Now, what you're referring to is another aspect of the relationship between the agent and the principal, the contract that is internal and separate from the relationship between the third party and the principal. So I think it's important to keep those two aspects separate. And it might be that under the terms of contract that the principal and the agent have concluded, the employer and employee, there will be a term that will limit the liability of the principal. However, there could also be a term in a contract that the principal has with a third party. So there could be, in general terms and conditions, there could be a clause limiting the liability of the shop towards any person buying a chocolate bar, and that will be subject to the usual exclusions and limitations, for example, Unfair Contracts Terms Act, or under Consumer Rights Act 2015. So all those contracts they're still part of general contract law, and they will be governed by the rules that apply in general contract law. But I think it's important to realise that there are those two separate sets of relationships.
So the principal will normally bear the brunt of liability, but there may be sort of sub-assumptions of responsibility on the part of the agent or even perhaps on the part of the consumer.
Well, I think that's part of contract law, which possibly when they are a part of clauses in the contract. But broadly speaking, if I understood your point correctly, then I think yes. But perhaps we could discuss that, follow that up in the break.
I think I understand. Thank you.
Okay. Right. On the PowerPoint, is the concept of power clear? Because it's quite important that it's relatively straightforward to everybody. Okay, I'll take your silence as yes. The concept of agency as power, power to undertake acts on behalf of the principal, can be described as an internal aspect of agency. When we think of agency as a triangle, right? Triangle shape isn't important. The fact that there are three parties entering into various relationships is important. So the idea that the agent has power to make the principal bound to the contract, enter into a contract on behalf of the principal, is part of the internal aspect. It's between the principal and the agent. It's often governed by contract, as I said. And that relationship is referred to as authority. So the principal usually grants authority to the agent to act on his behalf. By granting authority, the principal grants power to the agent to undertake acts to which the principal will be liable. If the agent then undertakes that act, exercises that power, the principal is automatically liable to the exercise of that power, and exactly what the consequences are will depend on the act that the agent has concluded. If the agent concluded a contract, the principal is bound by the contract with the third party. At that point, the agent is not bound, drops out of the picture, you might say. So the contract, the act, is concluded between the third party and the principal by virtue of the exercise of the power. And that appearance of the relationship between the third party, the fact that the relationship comes up between the third party and the principal, is the external aspect of agency. So the principal might become liable on a contract of the third party, but also the third party might become liable to the principal, depending on the nature of contract. For example, if the agent agrees with the third party that they will sell not one chocolate bar, but say 100 kilograms of chocolate bar supplied to a chain of shops, and the third party is a supplier, wholesaler, then the supplier will owe the duty to discharge the contract to supply the goods to the shop directly, not to the agent, the person who acted on behalf of the shop purchasing the bars. And that's the external aspect of agency. There are various types of agents. The basic ones that you will no doubt come across in practice are directors, and we talked about that already, who act on behalf of a company. Their solicitors also are agents who act on behalf of their clients. Sometimes you might come across agents who act on behalf of a principal in a contract of sale of goods. They will be tasked with holding possession of goods and selling it on behalf of the principal. And those agents are referred to as factors, sometimes as mercantile agents. And we'll come across those later. Now, there is a difference in the modern, so the term factor is an old term, 19th century term. Nowadays, you might come across the phrase factoring. Has anybody come across in modern practice or in commercial awareness the term factoring? That refers to something completely different. Factoring is used in the context of financing, and it refers to selling of debts, not necessarily on behalf of anybody. It's the transaction of selling debts, rights to be paid, for example, invoices. But we don't need to worry about that now. I just want you to be aware of that distinction. Now, most of agency law in English law is governed by case law. There is a directive on commercial agents, and if the agent falls within the scope of definition of the directive, then certain consequences will follow. The details of the definition, they're not particularly sophisticated. The agent must not be the employee of the principal. The agent must be also involved in selling and buying goods. And there will be rules that will apply to that relationship. But we are not looking at those in this course. So be aware, perhaps in practice, that something like a commercial agent exists, but it's not necessary to look at it now here. Now, there are distinctions between agency and other transactions. So the basic ones are the transaction of selling on behalf of someone else, and selling and reselling for your own benefit. So, for example, if I am sent a list of books, of textbooks by my publisher for sale to students, I might act as a facilitator of my students buying books from me. Now, the question is whether I act on behalf of the publisher and sell books on their behalf, or do I buy books from my publisher and then resell them as me to my students? This basic scenario is really underlies the case of Re Neville. Facts were very similar, and on the facts the court held that the person who was buying from someone else and reselling their own capacity acted on their own behalf. They're not as an agent. They emphasized the nature of the relationship that the person has with the potential principal. So there is no general rule that will give you an answer whether there is agency or not in each set of circumstances. But it's important to look at into each contract whether the intention of the parties, of me acting on behalf of the publisher, is that I act on behalf of the publisher and undertake an act that will put the publisher into direct relationship with the buyer or not. So that's something to be aware of. And I think this point is made, the importance of contractual relationship is made quite clear in the quote by Lord Justice Mellis in Re Neville, which you've got on the handout as well. Whatever the parties may think, it is their relation there is not of that of a principal and the agent. But in the first line, there is the emphasis, if you notice, on according to the contract. According to the contract. So it's about contractual interpretation of the rights and duties that are formed between the parties. Of course, those rights and duties will be seen in light of the law, so we need to know who the agent is in law to be able to answer that. Agency also is quite similar to trusts. Agents and trustees both owe fiduciary duties, at least usually, to their principals. And just like trustees, agents are accountable to their principals for example, any profits that are derived in the course of exercising their powers as part of their position. Another similarity is that the trustee and the agent have a power to affect the legal position of the principal, of the beneficiary. But of course, what's the main difference? When the trustee acts on behalf of or for the beneficiary, there is no contract created between the beneficiary and the third party, or otherwise some other act. The party to that act is the trustee and the third party. Whereas in agency, when the agent acts on behalf of someone else, the legal relationship created is directly between the third party and the principal. And the same reason applies to the distinction. This is the same distinction is visible in agency and bailment. When the bailee receives possession of goods and they hold the goods, they are liable to return them to the owner. They're under a duty usually to return them to the owner. But if they undertake an act with a third party, for example, have the goods repaired, there is first and foremost the relationship between the bailee and the third party. But there could be some similarities in certain specific situations, and actually repair of the property is an example in Tappert and Artis of a situation where the third party and the agent, the owner might have a direct relationship between one another. So in repair example, the owner of the property may still be liable for any fees in relation to repair, but it's very limited. By and large, holding of property on behalf of the principal does not put the third party and the owner in direct relationship.
Why not? So if there's been a sale of goods and you have the seller,
Mm-hmm.
and then you have the intermediary bailee who carries the goods to the buyer, how is that not an agency situation?
Right, so the person who has possession of the goods may also be an agent. But just because they're a bailee, they're not necessarily an agent for the owner.
But why not? Because they're entrusted by virtue of what has happened to act in some capacity for a principal.
Well, no, because they could be buying the goods for themselves. They could be, like in my example of me buying goods from the publisher, I obtain possession of the books and I might sell in my own capacity to other people. So I still obtain property from another person, and it will be under the terms of my contract with a publisher who has property in those goods. So it might be that they remain the owner until I pay them the price. I hold the possession of the goods, and I will nonetheless be able to sell those books to third parties. And that will be governed by, first of all, there's a question of contract between me and the buyers. But also there is a question of whether the property will pass, which is a very separate question to the question of bailment, which is focused on possession. So just because I'm in possession of someone else's goods doesn't mean that I'm an agent, because there could be a range of other relationships between us. Or it could be that the publisher has consented to me selling their books, even though they're in terms of they holding the property, but they agree to me selling the goods not as agent but as an independent seller to third parties.
So look carefully at the terms of agreement.
Absolutely.
Basically.
Okay. And a final distinction is between the agents and independent contractors or employees, which we touched on already. So all that's left to say is that the similarity is that in agency, the contract or other act that the agent concludes with a third party might make the principal liable to the third party in certain circumstances, and so does vicarious liability. The principal will be liable. But the concept of agency is much wider than vicarious liability. It involves a set of powers that or rights that the principal accrues against the third party. So the principal is able to sue the third party as well as be sued by the third party. It's a much wider concept than vicarious liability. Okay, any questions? Yeah.
Is it basic that if you've got the agent acting as an agent, then entering contracts or whatever on their own behalf, would they be called the principal when they're doing it on their own behalf?
When they're acting on their own behalf,
Yeah.
would there be so the question there is whether there is a pre-existing relationship with the principal. So they might be acting on their own behalf and appearing to the third party that they act on their own behalf. But actually, they might be acting in discharge of a pre-existing earlier relationship with the principal and buying or selling or entering into another contract for the principal. So in that situation, there will be an undisclosed agent. The third party might not know, and they might be thinking they're acting with an independent party and not an agent. And there will be a contract between the principal and third party. But whether that's the case will depend on specific circumstances of the case and whether the agent intends to bind the principal or not. Because if they're acting on their own behalf and they don't intend to bind the principal, but they intend to bind only themselves, so not only they appear to the third party that they act on their own behalf, but also they intend to act for themselves, then there is no question that there will be no agency relationship created between. This won't be in the as a result of agency, but there will be a contract, quite likely, between the person acting as agent, person of the agent, if you like, in this example, acting as a principal, yeah, in their own independent capacity with a third party. Okay. Any other questions? Okay, well, let's take a break and resume at 5 past.